Hello and welcome. My name is Pierce and I'm the chairperson of Germanic Society at Trinity, and we're delighted to bring you this collaborative event today with FLAC that we've been working on over the last couple of weeks. We think it's really exciting, we think it's a really interesting topic, and we hope you're going to enjoy it. It is, of course, the merits of a civil law system, lessons from Germany. This is a topic that is going to become more and more prevalent, I think, as we see different legal systems within the European Union clash and interact differently, and certainly assess problems from a different perspective. For those of you who have studied law, you'll know that Ireland is a common law jurisdiction, which means we place a lot of value on previous case law, on the concept of precedent. Germany is not so. Germany is a civil legal jurisdiction, which means they place their authority in codified statute-based texts. This event now, of course, is not solely for law students. It's going to be something that is going to come into so many different disciplines of academia and study. For those of you who have studied or indeed have an interest in law, economic policy, intercultural relations, comparative law, different legal systems and how they interact, this is going to be really important. And we have a great lineup of speakers today to help us explain the benefits, the advantages of the German legal system, and indeed how it compares to our own domestic legal system. To begin with, we have Dr. Christina Morgenstern, who is a research fellow at Trinity and who specializes in criminology, criminal law, procedure, and law and justice, followed by Philip Gavin, who is an assistant professor overseeing the law and German course in Trinity, and who I have indeed had help guide me through my own final year module in German law. And he's going to be looking at this from a commercial and corporate background in which he has a very, very strong grounding. So again, just to reiterate, we're delighted and we're so happy that FLAC have put in so much effort in helping us produce this event for you guys, and we really hope you find it informative, entertaining, and enjoyable. So thank you for watching it, and all the best.
Hello, my name is Christine Morgenstern. I'm a research fellow at Trinity College Dublin and part of Trinity Research in Social Sciences. And I will talk today about the merits of a civil law system, lessons from Germany. Initially, I was wondering what I could contribute to this topic. What do I know about the merits of a civil law system? Usually you don't look at your own system in that way, and to assess merits or benefits, it is necessary to know exactly the characteristics of your own system. What distinguishes one system from the other? Traditionally, I think it's the significance of written legislation that differentiates the civil law system from the common law system. Civil law systems have more of it, of the statutory law that regulates many, if not most, aspects of modern life. This legislation is both detailed and abstract, and the role of judges and courts is to interpret the provisions and to apply them to individual cases. When I got that far in my deliberations, I thought, okay, I can contribute to the topic and speak about German prison legislation, which regulates prison life in great detail, and I can speak about the jurisprudence we have in that field. I will mention how good it looks on paper, but I can also speak about what is interesting for a free legal advice center, namely the actual access to justice for prisoners. I can do so because I'm part of the PRILA research team that conducts a study on prisoners' rights, accountability of the prison system, and the rule of law. You will find more information on the project under the link you can see here on the slide, but briefly, in this project funded by the European Research Council and led by Mary Rogan here at Trinity, we explore prisoners and prison staff's experience with oversight, with complaints, and with rights in Ireland, Germany, Norway, and Scotland. And we have been in prisons in all these countries for our fieldwork, and I obviously was in 4 German prisons. Now, as for the German context, the civil law context, The significance of written legislation is something very characteristic for the German legal culture. But before the statutory law always comes the constitution. This is a lesson learned from the experiences of the Third Reich. So the German constitution, drafted in 1948, actually it's not called constitution but basic law, Grundgesetz. This constitution or basic law is key for the understanding of the German legal system. The first 19 articles are articles about fundamental or human rights, and the last of these 19 articles includes the provision: should any person's right or rights be violated by public authority, he or she has recourse to the courts. Of course, prisons are places where this can happen easily, that a person's rights are violated by public authority, given the power gap between prison administration and staff on the one hand, and the prisoner on the other. Nevertheless, effective and independent oversight over prisons and a complaint system was not in place until the 1970s, and prisoners had hardly a chance to complain before a court. Up to that time, the prevailing concept of a special, lesser legal status of prisoners had created a so-called special power relationship between this kind of citizen and the state. It was called besonderes Gewaltverhältnis, and we could find it also in the army and in schools. So this was kind of a special citizen. It was a citizen, a prisoner was a citizen, but somehow a different citizen. And under this concept, restrictions of fundamental rights were justified as such by the objectives of punishment and the nature of detention. No precise statutory basis was deemed necessary. All interventions could be based on administrative regulations. Not very civil law system. Now the second feature of this, our German legal system, comes into play. This is the Federal Constitutional Court, Bundesverfassungsgericht, that was established together with the Grundgesetz. In 1973, the court argued that every offender and every prisoner has a right to social reintegration, Resozialisierung, that accrues from his or her constitutional rights to personal liberty and to human dignity, or respect for human dignity. Prisoners, as any other citizen, have and retain all rights unless they are restricted by statutory law. This decision was a landmark in German prison history, as it ultimately forced the legislator to actually pass statutory prison legislation. In 1977, the Prison Act came into force. Meanwhile, the competence for prison legislation has shifted, and now it has been transferred to the 16 federal states, the Bundesländer, so we have 16 prison acts now. But they have kept what was introduced in 1977, a comprehensive system of oversight over prisons and a complaints possibility, or various complaints possibilities for prisoners. In addition to an internal complaints procedure within the prisons, a judicial complaint exists. So prisoners can complain against the prison, any decision by the prison, before a designated chamber of the regional court. It's called Strafvollstreckungskammer, now we just say prison court. Following the basic approach I have just mentioned, the approach of Article 19, each and every decision taken in prison, and even simple actions of prison guards, such as not knocking at the prisoner's cell door, can be made subject of a formal judicial complaints procedure. The idea behind creating a specialized chamber was to establish the jurisprudence of specialized judges who are particularly knowledgeable about prison matters and acquainted with the prisons located near the court. Research from the 1980s already and the 1990s showed, however, that this was not the case, and that these posts are something for young and unexperienced judges who often quickly want to move on to more attractive subjects. I think that prison law is very attractive, but obviously most of them don't think so and want to move on. So this did not really happen as the legislator had hoped. Now, how does this look in practice today, all this? On the plus side of our highly legalized and judicialized system, we do have a large body of jurisprudence now, with a lot of cases in which individual prisoner complaints impacted on the whole system. If not satisfied with decisions by the ordinary prison courts, the prisoner can use also, like every citizen can, but also the prisoner can use the extraordinary constitutional complaint and finally go to the Federal Constitutional Court. This court in particular, but also the other courts, have decided in important cases for prisoners with regard to searches, cell searches, body searches, with regard to visits and the control of visits, with regard to telephone calls. This is a relatively recent decision, so telephone calls were far too expensive. With regard to prison leave, early release, work and remuneration, all sorts of things have been decided in individual cases in favor of prisoners and had further reaching positive effects for all prisoners in all prisons. So that's definitely on the plus side. The second plus I can see, also drawing on insights from the fieldwork in our Prilla project, is what in criminal law theory we would call a general preventive effect. Staff is always aware of the possibility that courts can have a look at each and every decision they take, both at the procedure and the material outcome. And I just quote one participant of the study here when I asked this person about the judicial complaint system. Basically, I think it's good. It's just the rule of law, you know? It's just part of it. It is just something that one can be controlled and thinks, okay, I cannot make a blunder here. Sometimes one thinks, oh no, not again. I can't deny that myself. But when I think about it objectively, we could just be glad that we have this opportunity. And even if it is annoying and bothersome, we should be under no illusion. It's just like that, and we should all be glad to live under the rule of law. So that's quite encouraging. But prisoners would probably not subscribe to this positive assessment. And they did not in our research. There are indeed minimal chances for individual prisoners to win their cases. We do not have proper data here, but from our impressions and actually from a file study I did, and also from some other research, we think that perhaps 5% or 10% of all cases are won by prisoners. This means 90% of them are not won by prisoners, they are won by prison administration. And by far not all prisoners actually do complain, neither within prisons, using the internal, more informal complaints procedure, nor before a court. We should take into account here that depending on the prison and depending on the region, we have up to 50% inmates that do not hold a German passport. Many of them do speak German and are familiar with the system, but many do not, as you can imagine. We do have a lot of prisoners from marginalized groups, so some of them do not know how to read or write, or if they do, they don't think they are fit to write something official because they don't know how to express themselves. We also see a growing group of inmates with severe mental health problems. From the Prilla study, from a survey, and also from interviews with prisoners, we know that the majority of inmates never has complained, neither internally nor before a court. So that was about 60%. The reasons given were that it was not necessary because everything was fine, or it was not necessary yet. So you could say this is a good outcome. That was about 25% of them. Others said it's useless anyway. That was the largest group, about 1/3 of those who filled in the survey. And they said prisoners are not believed, they won't be doing anything, they won't be able to do anything because of resources, so all sorts of reasons were given. A small group rejected the system as such, so would not use an official tool to complain, and we can call them legal cynics, and they often belong to the prison subculture. And as the most problematic group from the human rights point of view and the access to justice point of view are those who fear negative consequences. Some just fear that the general relationship with staff would deteriorate if they complained, but others really spoke of reprisals. Sometimes they said there are explicit reprisals, like they would come and yell at us, something like that. And sometimes, or more often, they said that this could happen in the form of more subtle consequences, like delayed decisions, for example, on the possibility of having a visit, or that requests for phone calls or other practical things are delayed or forgotten. So if we take into account that with our research, we, at least in the survey, did not reach some of the most vulnerable inmates, prisoners who do not read German or English, or who have severe mental health problems, and I saw a few when I distributed the survey. Or also that we could not reach maybe some of those inmates who were too fearful to participate, then overall this is not a good outcome and is far behind what the legislator had hoped for. A last problematic aspect in this regard is legal advice that could be useful or necessary for the more sophisticated complaints, and in particular those before the courts. In principle, prisoners do not need a lawyer there, and there are a few, mostly German long-term prisoners, who know how to use and sometimes even know how to play the system. They can speak perfectly well for themselves, and that's always enough what they write to the court. But others, and I would say this is the majority, often feel that they should rely on a lawyer, but they fear the costs, even when these costs are actually moderate, or they would be entitled to free legal aid. This is also a problem because often there's not enough information how that works. We also have to say that most lawyers are not specialists in that field, not even defense lawyers, are not keen on working for prisoners. So often for defense lawyers, the thing is over once the person is sentenced and in prison. And there's not much money to make, and to be fair, in effect, it's very little. And of course, lawyers have to gain money for their lives as well. And when lawyers are active in that field, the quality of work often is not very good. So there are very few specialists who really do good work, who are very committed, but not many, as far as I could see from the files and as far as I was told in interviews, both by prisoners and staff. So to conclude, the highly legalized and judicialized system of prisoner complaints in Germany as part of the German civil law system looks better in the books than in action. While I would still argue that it's a positive thing or a merit of this feature, there's a lot of room for improvement, or as we say in Germany, there's Luft nach oben. So thank you for listening, and take good care in these difficult times. Bye.
Hello everyone. I just want to firstly thank FLAC and the Germanic Society for asking me to speak today. I've been asked to speak on the topic of the merits of the civil law system in the context of commercial law. I'm going to speak more specifically on the experience with company law and corporate governance, but I do think it's an interesting question to ask whether this common law civil law divide means anything in the commercial context, particularly because companies, as we know, are engaging in cross-border activity on a regular basis, particularly within the EU. So any differences that arise between the common law and civil law experience is going to have significant implications for those cross-border activities. One thing I do want to say on the outset, though, is company law is somewhat unique in its relationship to the common law than other areas of the law may be, because companies are inherently a creature of statute. The starting point of company law is statutory creation of the company. It is not, strictly speaking, a common law development. That's not to say that common law is irrelevant. Certainly, the law of equity has had significant implications for how common law countries understand the role of the company. But nevertheless, the starting point of company law and understanding the corporate form is with statute, a statutory recognition of the corporate form. And in that sense, it much more closely mirrors the tradition of civil law countries. That's not to say that the experience of Germany in particular is in any way identical to that of common law countries. Indeed, we've seen that experience is quite different. But one thing I want to focus on today is why Germany may be so different to us in its experience around company law and what those differences may mean for us in future. One of the reasons why the law around companies is different in Germany and to common law countries is around the block holding of shares. So a block holder is someone who holds a significant block of shares within a company. And what we tend to see in civil law countries, in continental countries, is a tendency for shareholding to be quite concentrated. So that means that you have one or more shareholders who control major blocks of the shares, whereas the opposite of that is when shareholding is dispersed. And dispersed shareholdings is when there are lots of shareholders, each holding a small number of shares, a small piece of the pie. If you look at the graph I'm showing you here, it's a source from 1996. What you see is largely it's continental countries with the concentrated block shareholding. And then as you go down the list, you start to see the common law tradition has less of a block shareholding, particularly the US and the UK, which of course are more commercially significant jurisdictions than Ireland maybe. But on the other side, you have Belgium, Sweden, and Germany is further up the list than Ireland would be, and certainly far more concentrated than the US or the UK. And first I want to say the reason I'm using a 1996 source, there's an intention there. It's because to understand where the law was nearly 25 years ago and to understand the trajectory of shareholding now and what that may mean for company law reform going forward. So this is a bit backwards looking, but that's intentional to understand where we are now. What does it mean in terms of corporate governance when shareholding is concentrated or dispersed? Well, when shareholding is dispersed, it's quite difficult for an individual shareholder to hold management to account. They don't have enough shares themselves to tell management what to do, and it's also difficult for them to coordinate with enough shareholders to get through a vote on what they want. So it's quite difficult for them to coordinate amongst themselves to hold management accountable. This is typically referred to as a collective action problem. It is quite difficult to get them to act as a collective effectively. The problem then is management feel free to do whatever they want. They can either work for their own benefit, or they can shirk their responsibilities, or even something less nefarious than that. They might be acting in the interest of employees or customers or other interested groups, but just in doing so, ignoring the wishes of shareholders because they feel free to do so because they know it's quite difficult for shareholders to hold them accountable. So what you're concerned with then in a dispersed shareholding situation is ensuring the law holds management to account sufficiently and ensuring that there are mechanisms in place to keep management accountable despite the fact that the shareholding is dispersed. Contrast that to a concentrated shareholding model. You have one shareholder who has enough of a vote to hold management to account. And the concern then is not that management won't do what the shareholders want because they're being held accountable by the major blockholder who doesn't need to coordinate with other groups. But the concern then is that major blockholder, that shareholder who holds all the power, is now in the position to disadvantage other shareholders to their own benefit. So the concern of a concentrated shareholder model is not that management will do something inappropriate, but that the shareholder who controls all the power will do so. So the two models are inherently concerned with a very different problem insofar as corporate governance is concerned. To put that into clearer terms, perhaps, Here we have a graph showing the largest shareholdings at the time in the mid-1990s. In the US, the median largest block holding in companies was about 5.4 or 8.6, depending on whether you're using the New York Stock Exchange or NASDAQ. And in the UK, slightly bigger again is 9.9. So they're not insignificant shareholdings by any means, but they're certainly not enough to control the company on your own. You still would need to be coordinating with other shareholding groups. Contrast that to Germany, the median size of the largest voting bloc was 57%. So you're over half the votes yourself. So that block of shareholders in the German system is able to push through whatever reforms it wants, even if that other 43% rally against them, because they, as a bloc, control enough of the vote. So the US and the UK are concerned with management not listening to them because they need to coordinate amongst themselves, whereas the German approach is concerned with that one block of shareholders being able to do whatever it wants. So what does that mean in the context of company law? Well, one very common contrast that's made is in the instance of co-determination. So Germany is often shown as an example of labor representation in the kind of global market, and as a model of labor representation. Germany has works councils which negotiate the labor conditions for the workers in the companies. Germany also has what's known as co-determination. Under the Co-Determination Act, the Mitbestimmungsgesetz in Germany, any company that has over 2,000 employees must have equal employee and shareholder representation on its supervisory board of directors. So it's half employee representation, half shareholder representation, and then there's a chairman who is the tie-breaking vote, and the chairman is, of course, pro-shareholder. So it is still ultimately going to favor the shareholders, but what you're allowing to happen in the German model is a consolidated labor voice, a consolidated labor representation in the company. And that might be necessary in a German model because what you have is a consolidated capitalist voice. You have a consolidated shareholding voice, and you need something to offset that with a consolidated labor voice. That might not be necessary in the common law countries because there is no consolidated capital voice. There is a strong manager voice, but the shareholders themselves are not consolidated. So you may think we don't need to consolidate labor representation. Well, is there a comparison to be made here? Do we need to care then? Well, I would argue, yes, we do, because in the current trend of how shareholding is structured, things have changed quite significantly from the graph I showed you earlier. There are now major investment funds who control major blocks in shareholders. The big three investment funds, BlackRock, Vanguard, and State Street, collectively control 16 trillion worth of assets. And they are fast becoming the major block holders in companies. Here's some of them for you. These are the equity firms and the amount that they have under their control. And these are hedge funds. So similarly, we're seeing a major rise, obviously the exception being the recession in 2007. But what you see are significant numbers of assets being pooled into institutional investors, into major investment blocks. And when those investors in investment funds invest in companies, they're able to obtain major blocks of votes. So what you're seeing is that capitalist voice in the common law countries may actually be concentrating significantly. We may be going away from a dispersed model of shareholding to a model more closely resembling that seen in Germany. For very different reasons, of course. The reason it's happening is because of the rise of the institutional investor. But nevertheless, you're seeing this concentrated capitalist voice. So if there is a concentrated capitalist voice, do we need to start thinking about a concentrated labor voice, something that Germany does so well? Well, we have seen suggestions of that. We are seeing moves towards a concentrated labor voice. One example is Elizabeth Warren's Accountable Capitalism Act, which argues that co-determination should be brought into play in America. The co-determination, the German model, should in fact be the norm in American companies going forward. And that is, of course, something that's been borrowed from the civil law tradition. So it's important to consider then how the common law and civil law countries deal with these issues. One has historically been dealing with dispersed share ownership. The other has historically been dealing with concentrated share ownership. And there are certainly lessons to be learned now from the German model as we start to deal with those issues that Germany has been dealing with for so long. I believe that is my time. Again, I want to thank you for inviting me, and best of luck with the rest of the presentations.